Your Worship, the first respondent has not given this final report sufficient reason as why they did not seek to first have the video evidence admitted before we went into submissions or the merits of this application. Your Worship, trial has steps and stages. Your Worship, adducing evidence comes before parties go into submissions. Your Worship, bearing in mind that as at this time, the applicant does not have this electronic evidence, and that this same alleged evidence did not go through the preliminary stages of being admitted in court report. Before the hearing of the applicant's case, when the approach being taken by the first respondent is prejudicial and contravenes applicant's constitutional right to a fair trial. Your Worship, we pray that the evidence be rejected and the court proceeds to write a ruling on the merits of the application. That's some prayer.
You want one thing for the second? No. Cancel for the second.
Your Worship, for the second response. Your Honor, this being the court of justice, it is only in the interest of justice that any evidence properly before court be admitted. Your Honor, it is true that the said evidence may not have been served, but if court finds justification justification, it should proceed to allow. It should proceed to allow video coverage, just like it allowed service by WhatsApp in the shortest period possible. Therefore, pray and submit that there is no prejudice if it is allowed in the part of the situation.
Okay. Okay, Adjournment.
Worship, when my brother, senior counsel Asman Basari, was making his opening remarks, he started by praying that all the evidence of record, all the affidavits, be adopted as evidence of record. And worship, court, according to agreed with him and admitted the evidence on record without any objection from my own brothers. Worship, when I was doing my submissions, I intimated this and I put worship. But we intended to make an application about having the video played in this record. And worship, this court directed, guided, worship, this court guided. So this prayer should be made when we have closed this submission. Try to be attentive to this. Your Worship, this evidence has been recorded to court since yesterday when it was filed here. We are calling upon this court to exercise similar magnanimity, and extend an olive branch to us that it only extended to my young brothers of the agriculture. When the court allowed us to proceed on the receipt, we are not seen. That was on board record. Worship, as an old maxim goes, what's good for the goose, good for the gander. So, Your Worship, we pray that this video being played is the interest of all of us. It's an exact recording of what actually happened. Court, by viewing this video, it may choose to rely on it or not want to rely on it. And Your Worship, to make my brothers comfortable, you can give them a chance to address court after watching the video. submitted here vehemently that a lot of injustice was occasioned during counting. All these questions, we should be able to see them clearly when watching this video. It's for all of us, the applicant responding and easy and what, which was not there. See a better picture of what actually happened. So actually there's nothing wrong here by having this video.
If I may. Yes, I'm worried that we are not proceeding. Because the submission now is like opening up afresh. I thought you were going to give it.
Opening up a fresh what you had said earlier.
Can I please? Yes, we need to be a help, but the man has also. Please, the submission should be restricted to the rejoinder of matters that exist. But opening up and submitting afresh and saying this video contains this, we don't know the time video we're talking about. It's not, it was not sad. Then at the end, you're inviting the court to play it. Crucial as it is, as you suggested. At the end, this is just a deliberate. This is just a deliberate. I'm off record. This is just a deliberate ploy to delay the proceedings, and we invite the court not to fall for the first respondent's actions.
As I conclude,
You also record now.
okay. So Your Worship, we are saying that this video, at least we are not somehow getting caught right now. It's been caught. And one, this, that should be the same video right on.
Okay, for start, what would be the idea? First serve them. Because if they don't have it, how do they want to have?
But Your Worship, even suddenly here, we'll still go to watching it. So I don't know, you first watch it and then see whether to agree to it to be played or not.
Because you see,
Once we are playing it here, it's for the benefit of all. They will be seeing it word by word, step by step, and they can refer to it.
But Your Worship, if I may.
Because this just
record now. We are not
Yes, yes, Your Worship.
colleagues.
Really, we come to court, present our case, analyze our evidence. We submit, we all close. Then a party to the case is having a video under its cloak and keeping quiet. Then after hearing our case and our analysis, then you say, now, Your Worship, surprise. Really? Off record, these proceedings are even being televised in Kenya and why? They cannot see us proceeding like this.
So
Anyway,
you understand from camera.
I'm disturbed by how we are
camera now.
Your Worship, I'm disturbed by how. Mr. Masako, just 1 second, I finish.
You also will make your submission.
And then it's the only record. Not only I beg to be on record.
No, but in the judgment, you disturbed you in what?
Yeah, I would have.
I beg to be on record.
Okay, let him finish.
You be off record. I beg to be on record.
Your Worship, we are not proceeding, right? And Your Worship, even this arising and the talking and the it's all a deliberate ploy to delay these proceedings. It's just a deliberate ploy to keep the court in circles, take it back, then as perhaps something goes under. We object this kind of procedure is being adopted by the first respondent. It's not good for our courts, it's not good for our fraternity as lawyers, it's not good for us to be more here.
Okay, now let me hear.
Your Honor, in rejoinder. As I said, I beg to be on record. In rejoinder. Number one, Your Honor, it was the guidance of this court. This procedure we are adopting now arose out of the guidance of this court. It is not a procedure that we are introducing. Because, Your Honor, an attempt was made by Land Council Kamukama
What point?
at the point of
When I was about to tell
at the point of when he was concluding his submission,
Who submitted first?
I submitted first. Then he was concluding.
Then you wanted to make it.
Then at the conclusion, he said, Your Honor, we have.
Because you see, his argument is very simple. That if you're going to you want to play a video or to present evidence of that nature, you do so before submissions. You have that was in between submissions.
Your Honor, that is what we wanted to do.
Before?
That's what we wanted to do.
Before?
Okay? Not before, during our submission. And it was guidance of this court that you raise that matter at the tail end.
So the right procedure is you raise it in between submissions.
You see, Your Honor, once our affidavits were adopted, because you see, Your Honor, already this document is on court record. We could even decide to leave it for court. Yes, because it is on court record. Okay? It is on court record. And Your Honor, the procedure we are adopting now is not alien. They themselves have benefited from it. It's not alien. It's not alien. And we will submit it. We will submit that since it's on court record, we leave it to discretion of court. Yes. No, but you don't direct me on what to say. Yes. Because if your argument is as hollow and empty as the grave of Jesus, how can that be my problem? So, Your Honor, I want to submit that why are we here? It was on the guidance of court. Because we know the procedure of introducing evidence. We know it. And we are right to it. So it was on the guidance of court. But to Your Honor, why are we also in this question? It was because they sought for an expert application that resulted in two deadlines that were rather cumbersome. That's how we have found ourselves here. And then the application is on court record. It was hard experted. So why are we here? Now, Your Honor, as I indicated, this particular point that we are raising is already an attempt. An attempt was made to strike it off. It was unsuccessful. So it is evidence on the court record. But Your Honor, how would the applicant be prejudiced by the public display of a video that would be able to prove his case that the votes were given to another candidate? How would he be prejudiced? Because this video cannot strengthen his case. Because he's saying that votes were given to another candidate. And we are bringing a video to show that indeed votes were given to another candidate. And say, no, don't bring it. How would he be prejudiced? So, Your Honor, it is my humble submission that this honorable court is pleased to allow, since it was the guidance of court, to allow the video to be played. But in the alternative, and without prejudice to the applicants, since the document is on court record, we pray in the alternative to leave it to the discretion of court.
Maybe only off record.
Off record.
But what is off record helping us here? I think we are going into private conversations that are not of evidential value.
How to manage this? Off record?
Your Worship, off record. This is a court of law. Courts of law have procedures. You see, it is not a dispute like apartment like intimated, but you see the stage at which they were. Actually, no, it's not a different apartment. The stage at which you were supposed to do this evidence was when you resumed at 7, after making a deal with the peoples, that was the right time of making the application. Then after having that evidence admitted and obviously, now we go into submissions, because now, even the applicant, before she makes submissions on her case, she's supposed to first know what is there. The evidence is supposed to be proper on the court record, but we cannot operate as if we are not a court of law which has rules of procedure. This is not a mere when you get to a different place. No. This is a video which I think they trust, because the applicant is not worried. They claim they have a trusted video to bring in the court as evidence, where they never served it on us, though they served electronically. What was very hard to serve in the video electronically? If you are serving electronically, now, if you could put it on court record, why would it be very hard since morning to give us a CD over? Or why would they do serve it electronically? You are bringing the video, act as evidence in an election matter. Parties submit, respond, we join after closure, people are going to say, now what to play for. This is not a casual place. This is a court of law. Let us respect the rules of procedure. Otherwise, we shall fall into problems. So we are not worried of the evidence which we have. We are saying let us follow procedure and let us not allow people to make afterthoughts and ambush us in the wee hours of the night. So our position is very clear. On the side of the applicants, the case has been closed. And you have to go time to watch things which are on the road. The judgment may go good, but when it is not evidence. So that is the status of that song. We don't know that it's on record, but it is there, but it is not evidence. So that is our position as applicants.
Worship, now that we are making a conversation. You see, when my brother submitted that our affidavits be adopted and court agreed and adopted them, it meant also the annexes were adopted. And that one, they never made an objection in their submissions that part of this evidence should not be adopted. So to me, I believe they cannot go back. It's not on record. Now, take on record. See, and what having around us that should be on record. Then, if my brothers are not comfortable watching it themselves, they have your discretion. You can say, God can watch it alone. But what we're really trying to make clear that evidence is on court of record. And when we applied to have affidavit admitted, after submitted evidence, they never objected to it. It formed part of the record from that onset. As simple as that. So, even in practice, we have seen after submissions, court visiting locus. Yes, court has visited locus. Now here, it's watching a video. In conclusion, what happened? And actually, when they visiting locus, God is also made submission to locus. So to me, no, it's part of submissions. So here, at locus, also parties made submissions at the locus. So still, when we're watching this video and when watching this finish, they will respond to it. Will make also response. And this case is finally closed. And saying that this case was closed, that's not true.
Now you suggesting after watching again other submissions.
If they feel that, you see, avoid prejudice from them, the way they are arranging it, which I believe is not, because this evidence is already part of the record. If they feel they can apply to court that we need to make a few clarifications.
For starters, how is an exhibit for an affidavit tendered in part of the procedure? We are off record.
Your Honor, was An affidavit is admitted evidence. It follows that annexures attached to it. But annexures to an affidavit are part of an affidavit. Once an affidavit is tendered in the court, so are annexures. It's really as simple that where you are proceeding by affidavit evidence, annexures are part of the affidavit. And that's the point we are making. And that's why in my opening remarks I say we pray that our affidavits be adopted. That was the import. And the reason we said so was that because of the limited time, there was a possibility of not making reference to all the elements in the affidavit. But already the record was capturing that all our affidavits have been adopted in total. It's like you're all aware we have written submissions.
Okay. From council, what is the procedure of tendering the report? An exhibit attached to an affidavit. We are all of record.
Yes.
For the benefit of the young lawyers here.
We have an affidavit which alleges that there is an annexure attached.
I'm first and foremost asking what is the general procedure?
But from the reading of that affidavit, that's electronic.
You first leave the affidavit alone.
Yes, sure.
What is the procedure of the meeting of court record attached to an affidavit?
Generally, the procedure of admitting an annexure in form of electronic evidence is different from admitting just a letter or an annexure in terms of the document.
Okay, before that, let us first talk about the general procedure of admitting an exhibit attached to an affidavit.
The general procedure is that you mention it in the affidavit and attach it to the affidavit, appear before the commissioner, and that particular annexure is exhibited and marked. Then
they want to know at time of the hearing of the application.
now, for the hearing, Your Worship,
Basically, I wanted to know, because you give me the answer, how to tender the report, an exhibit attached to an affidavit, at what point can it get on court record?
Your Worship, for the electronic.
No, I didn't.
Your Worship, I've answered your question.
No, I'm not having the answer.
Okay, Your Worship, this is the answer. Generally, is that if the evidence is adopted, if the affidavit is adopted with its annexures, without objection from the other party, and then they are properly exhibited by the commissioner for oath.
You mean at that point now you go to the commissioner for oath? One has made the affidavit and the exhibit and the affidavit has been adopted on court record. Sorry, one makes the application, the opposite party has not objected.
Yes.
Do you now go to the commissioner?
No, you do not go to the commissioner, but the court, while reading this evidence, the affidavit, and it finds annexures attached, and those annexures are properly annexed to the affidavit.
And the opposite party does not object.
Yes, then they form part of the record. But Your Worship, when you restrict your questioning generally,
Okay, now we can give a specific one.
now, when it comes to electronic evidence, the other rules under the Electronic Transactions Act and the regulations made there under come into play. That's why the first respondent is seeking to play that video. Then after playing the video, he applies it to be admitted. That's a specific procedure for electronic evidence.
Okay, what if they don't apply for the same to be admitted?
Sorry?
What if they do not apply for the same admitted?
If they don't apply, then that document remains as an ID on court record, but not an exhibit. It remains for purposes of identification.
So for
if it is attached to the affidavit and you have filed it in court, once the file is called for here, at the time when the court was asking us if we are ready to proceed with the hearing, it's at that point that you bring to the court that I have a video which I earlier on put on court record, shared with the second party, and then you request the court to play it. Then the person who prepared that affidavit, who extracted it, takes court through that video, and once the court has watched the video in court, in presence of both parties, then the person who seeks to rely on that particular evidence or that attachment in form of a video applies to have it admitted as an exhibit. Then after, if I may deliver this point, then after, it is on the other party to object to the tendering of that video, and the requirements are provided for. The case laws are very clear and very many of them.
let me ask.
And also, if I may, we also indicated to the court that we were reserving our objection in respect to that particular video when the right time comes, and that was them seeking the court to play it.
Okay, now let me ask what if it was attached to your service, what would be the procedure?
Assuming it was attached, I beg your pardon?
Assuming it was served until you when they were serving that they are responsible.
Your Worship, still my submission would still stand. The purpose of serving it is then to give us notice to prepare how to argue it.
You go through, you determine whether you
We would have an objection and whatever, then we come prepared to object after it has been played. But now we are here, it was not served. They did not apply to have it played, and then after they tailored it in.
to me, maybe the issue there was service. I think it's served on you to take one of the opportunity for your time, like you already their replies would be the same way you also go through
So now we
video.
They have had our case. We have stripped ourselves to them. Yes. So they already had our case. Then after hearing our case, they want to bring evidence which they did not serve on us. And then they are saying it's a matter of
Okay, now,
justice.
at least just a little bit, we are still on record. They attempted to give reasons why service was not possible at the time of serving the replies. The reason was that given the nature of this matter, this court had guided that the service is on WhatsApp. And the reasoning behind this matter is those this time the respondents looking out for counsel for the applicant. Because I was looking at this question, the respondents find here they even themselves physically, but many traveling back up to Kampala. By the time they reach Kampala, we saw it. So, in avoidance of just technicalities, I came up with the approach service via WhatsApp. Now, the argument is that service via WhatsApp was not possible because the size, the size of the video could not be sent via WhatsApp. That was the argument. They made that argument. And no, that's the I'm sorry they made that argument. That was the reason why we did not serve. But it was attached on the court record. Then again, as I wind up off records, they've made an argument of prejudice, which is very key. Determining whether additional evidence can come on record or not. Because basically, I will not quote them, but they are quoting them the service. The service, according to this morning, we want to have served. Because now, we want to sleep on record evidence that they have not. You get me? That's why I have a problem here. Had they gone through the evidence? Because now, they will even tell you by the time you are making the no objection to your prayer. You have the affidavits admitted. They will tell you what they had. If you are not part of the affidavits, because it's not yet in their possession. But now to cure all this, at this morning, prejudice. I used to be placed in a jury. If, for example, say, to allow them the leave to serve you, we give you time to appreciate the video, then you make your valid objections to the same. Because at least I also appreciated their argument of we could not serve the video, given the size of the video, you cannot provide a serve, which is also genuine. That is if it is true, because I'm not admitting also. If that is true, it would be a good reason why they never serve. But since it is on record, cure that difference, like I'm saying. My ruling would be they officially serve you. The very first meeting, if you go through the video, then you make your response on whether the same should be eliminated or not. Very good reasons. And for example, if you allow the same, the court would allow, but is to only and only submit on the video. Because you see, the beauty with the court is that all is possible, provided there is a fair hearing. If the principles of natural justice are there too, all is possible on planet Earth. Because at the end of the day, we have that provision that which section is it that we love most? The CPI.
98.
We love that provision. Lawyers, you normally put it, why can't feel it? But my point is then prejudice. For example, because I have told you, they have their reason why they did not serve. I also have it on court record. When they were fighting, they continued. Okay.
Your Worship, I do not know why the court is choosing to trust that the business adjournment.
No, like I've said, I'm not an IT expert. I don't know, but that was the reason they gave. Unfortunately, when the reason came, you people were silent, you did not rebut.
Worship, if I may, we were clear that we were reserving our right of doing the right thing.
Okay, now you see.
But you worship, if I may deliver response.
Why?
The same method they used to prepare one copy for court. What stopped them from having another copy for the applicant? If it was that huge, not to this up or WhatsApp, Google Drive and whatever, but they should have at least retained one copy and then come with it in the morning and give us a copy. I'm saying it's here. Then we would be now arguing late service, but we would be having it. Then we even raised it in the morning and said, but we don't have that copy, it's not attached. Then they gave the reason that it's wrong, it's huge, and why it cannot be served via WhatsApp. They still opted not to favor us with a copy. It's a deliberate move for the first respondent not to serve that long, big video. Why? Because it will take time. Once we reach at the end, we shall ask the court should have mercy and justice on them, and then play the video.
Now,
So the worship that conduct, I humbly submit that is conduct the court cannot excuse.
no. Now you first listen to my opinion, because the prejudice. I'm still getting on record. I was basically saying that I was looking at the principle of natural justice, and what are the principles? Since they see it in the evidence, they invested in the evidence, and the review of evidence is evidence. If they have it with their evidence, with the circumstances that they've explained, the same will be served at 20 people. You can request for time if you so wish to make your responses to the same evidence. Now, if you made up your time, you are responsible on whether the same should be admitted or not. So you still get the time to make your arguments on whether the same video should be admitted on record or no. Now you'll be quoting the conditions you're talking about. Because mine is for justice to prevail. We would just follow that procedure. It is given unto you. Then officially you can make your responses. Because when they were applying to have the affidavit adopted on record, I would assure you, for your case, the video was not part. Yet, surprisingly, it is on court record. Now you will see how funny it is. So to cure that, my lady says that it is served on you. Officially, you make your response on whether it should get on record or not.
Your Worship, it's my humble submission that the guidance is not fair. Why? They have had our case. We have analyzed our case and all our evidence. They have had it.
Now,
They must have identified through the submissions. Because we have evaluated the evidence, they have also evaluated theirs. So they are going to use that video to on our prejudice because they know our case.
No, that's what I'm saying. That's all. I'm not saying that. I'm not saying that once it is served on you, you're going to not object to its tendering in court. Basically, I'm saying once it is served on you, you have your right to still object. But now this time round, you're objecting on the admissibility of the video. And now the video is, for example, let me add this one. If you think you have evidence to rebut it, or you wish to cross-examine the same, whatever the reasons, what we made condition, I don't know. But my take is, given the circumstances as they are, that surprisingly the video is on record. When they were filing, it came on record. And then it is active as I speak. Now, you counsel for the applicant, you don't have it. You get me? So I cannot just push it away. My take is like I'm guided.
This is an adversarial system. This is an election matter. In an election matter that you first hear our case, and then you go back, bring other evidence. It's not just enough to say that we shall be given a chance to object. Because now they know what to use it for. They know how to go against our arguments using that video. It's not just enough to say that we can I, Mr. Kamkama, please, can I first submit?
You see, you are discussing out of frequent.
Okay.
Can I please?
You will also get the floor.
It's not just enough to say, okay, we shall allow you to object. When you have already looked at my nakedness of evidence, the analysis, the rules of a fair game dictate that once we start the proceedings, all the evidence is there, and now we are submitting on it. For Christ's sake, we have submitted in closure. Then,
Okay, let me ask you some more. When parties close their cases, is it there are circumstances where one can be open their case?
in the rare of the rarest, and no evidence has been laid. Non-service of evidence or documents is not among them.
Okay, just wait a little bit.
Reopening is where there is discovery of new evidence. This is not new evidence. They had the evidence.
No, but also, we should appreciate that the sentence of court. Anyway, I'm not going to make a ruling.
Your Worship, the court can make its ruling, but this is unfair to the applicant to hear our case. We close it, we submit and say this is the best we can offer as our evidence. Then you say, okay, we have had your evidence, now we still have more. Let's do this again. We have displayed our cards. You have looked at them. You know we don't have a joker, you know we don't have this. Then you say, okay, take back your cards. By the way, I did not tell you I had a joker. That's not fair. And I invite the court not to take this matter lightly. It cannot and it should not. This is very unfair. It is, no, it's my submission. It's the highest travesty of justice that you hear one party. Then after they close their case, you say, I had some other evidence which I had hid from you, but I managed to put it on court record, but I kept quiet about it. We raise it in the morning, you don't serve again. Then at the end, you say, okay, now let's look at this evidence. It's not enough to say that once they play that video, we shall rebut. It's not. They have known our case. It's highly prejudicial to us. Even saying that we have a chance to bring in any other evidence.
Should have time as well. Because someone standing for 20 minutes.
You are not running us like this. It's not fair. You are not the one managing.
It's not fair. You cannot run us as a show.
You are
for 20 minutes or 30.
You are not the one managing the court.
Okay, why not? In 2 minutes.
In 1 minute.
Okay, 1 minute.
This is the highest travesty of justice. To allow new evidence, which was deliberately hid from us. Even when we complained in the morning that you had the evidence, you did not bring it out. Then you wait at the end and bring it out. It's not fair. It's not. It is not. Your Worship, I must also highlight that election matters should be handled very, very carefully. Not to cause pain in hearts of the people who are aggrieved. You look at the evidence and then you can bring another evidence. We do not want to land in election. Yes. The election matters are serious and they should be treated with the seriousness. The seriousness. No.
First of all, I want to apologize. As a senior member of the bar, I want to apologize to you as court and also the public. I want to apologize. Ideally, we should not be out shouting each other because this is not a shouting competition. This is a court of law, art of advocacy that we are told that LBC requires that there is decorum, there is civility. In fact, the legal profession is where you can make objections without not being objectionable. So I want to apologize, and I want to impress it upon our colleagues that this is not the last court. When this court makes a ruling and any of us is dissatisfied, there is recourse elsewhere. Your Honor, as a matter of fact, I want to confirm to you that we felt the prejudice when you admitted receipts that had not been served with us. That alone would have led to a dismissal of this application. That alone. But in the interest of justice, we kept our peace. We didn't do so because we cannot shout. Or we cannot threaten court. Yes. We did so because
No, at least I'm not threatening.
we have, yes, we did so because we appreciated the judicial path that this court was taking. Otherwise, how else does a receipt reading something else become security for us? How else does it come? So, how else does it come? When it was not served on us, we conceded, we accepted for the sake of justice.
I want to write my ruling. Okay, finish that one.
So, Your Honor, I just wanted to say we are sorry. We are sorry. I think as officers of court and as a senior officer, we have a duty to maintain decorum. I want to call upon all of us who are here that if we are dissatisfied with any outcome of this process, there are higher courts. They can be recourse to any higher courts.
Okay, let me
So,
write my ruling.
what I was wondering, I was always stepping up and down and going down. It was only a simple clarification. That when my young brother made a remark that we want our evidence to be adopted on record, and my young brothers didn't make an objection, especially as the lack of having annexed A in their possession. They conceded to it by not objecting to that application we made, and court ruled that rightly we are already on record. When we are already on record, that evidence formed part of the record. And only by making this application to be played, maybe it's what it woke them up that there is evidence that has now passed on, which and is now on court record. We should fight. We are not trying to smuggle a piece of evidence. We are dealing with this of a piece of evidence, but maybe for their own satisfaction now. They can have a copy. I have a copy here. You can give it to them. That's the case. But that evidence is only with you. It's only part of court record. It was only objected to. And when the affidavit of Mweswa Alan was allowed to form part of the record, it formed it with its annexure. And there was no objection at that time. So it passed the test. So when they wanted to raise objection, so at that point they were going to raise an objection. They didn't raise it. It passed. So they cannot say that we never got it at Washington. Only we only requested for playing it, but it was really part of the record.
Your Honor, 1 minute. Your Honor, for the second respondent, will abide by the guidance of this court. And I believe it is not good practice for us to raise voices when we are submitting.
No, at least I remember it was off record. No, still off
Still,
record.
off record, we must be courteous.
You also want to...
Yosh, me as counsel for the applicant, I'm having serious challenges regarding the execution of my professional duties. Because you see, once an applicant is served on you start the it, then you determine how to handle the gender parts. Then once a certain evidence on that reply is not done, as an advocate, you cannot determine how to make a response to that evidence. So at that stage, you are still at pleadings. So now it means when you come back to this video, they might even require again us maybe making the joining us to that piece of evidence. Because remember, this piece of evidence originates from an affidavit in reply. So when you go back at pleadings, as an advocate preparing a case for your client, you have to analyze the evidence on the reply. Now sit down and say, okay, now we are going to make a joinder to this evidence. Now, when after making the ruling on criminal objections, now we came to the hearing of this main application. Now the first stage is evidence. Now the affidavits which were retained were evidence of the court. But again, still at that stage, we did not have evidence or video evidence. Now it was at that stage. Actually, by the time we filed our rejoinder, we did not have a chance of getting the respective witnesses. You watch that video, you say, okay, as an applicant is ABCD in this video now. Do you have witnesses to handle this aspect? Then you file a rejoinder. Because we read various cases of the Court of Appeal relation matters. Even someone who has initially not made enough of his support can file a rejoinder to handle aspects arising out of advocacy group. Now, the serious weakness after closure of the case, we are going back at pleadings of worship. And now we are into rules of pleadings. These are constitutional rights, evidence, challenging evidence. So, whereas initially we had good reasons for not serving us that evidence, but there was a stage at which when we opened the main application, when we were supposed to now deal with that evidence, then injustice which may not easily see. So if they had it, they forgot to make that application at the right time. Now when after closure, now they are taking us back at pleadings and evidence which can, and these applications for vote you can start time about your worship. You have about only 4 days. I think 4 days. So you cannot keep going back and forth. Otherwise, you may never achieve the whole purpose of the vote count application, whether we shall win or not, I don't know. But you may not achieve the whole purpose of the vote count when you keep going back and forth. It is stage 1, stage B, stage C. You can't usually go back at stage 1. You are going back at pleadings. So that is on my part. I might apply to get out as far as proceedings for that if there's a concern, because I have challenges. Because now you are applying to open a case. Opening a case after you have closed. So I agree, they had reasons for not serving us, but the right time to apply to do it, they did not. So it is a mere after, so let us not waste time. Let us have a ruling on the main merits of this application. That is my view, Worship.
Talk about that from you now. This is my idea. At what time would allow buckets getting left? So my way forward is, I'm going to adjourn this matter up to next week on Tuesday. That's when I will make a ruling on this one here, this application. On that day, for example, if I overrule the application, then I will also deliver my ruling. If I allow the application, then we shall see what goes the same way. According to my mathematics, my 4 days depend on Wednesday. Yeah, because I thought time is allowed now, but yeah, we need people go back home early. It's actually late. So I thought of determining this application currently today, so that people go back home with clear mind. Yes. So we meet on Tuesday next week at 9 for a ruling on this application. So let us take up on Tuesday this week.
our dereva by the way.